which have been given and selected by the court or by the committee of the court, basically deals with different facets of the law as it has been developed by the Supreme Court. Because what the court does is, in exercise of its powers under Article 143, is to essentially interpret the law as a constitutional court. And I must bring this to your notice before I proceed. If you do see the provisions of the Constitution, you will find the rules of the court, which are set out in Article 143, and the powers of the President to consult the Supreme Court. Please see the scheme of what the court has to do in such matters. One is the power of the President to consult the court in matters involving interpretations and questions which are troubling the President for an opinion. Now, when this happens, the court is supposed to constitute a bench which has been given specific jurisdiction to deal with the questions referred by the President. In addition, very often there are doubts in the working of the court on the correctness or otherwise of a judgment, maybe of 3 judges, maybe of 5 judges, maybe of 2 judges. So they are referred now to a larger bench for the purposes of deliberation, consideration, and judgment. This happens in myriad cases. You will find a lot of references are made to larger benches. 2 to 3, 3 to 5, and now 5 to 7, 7 to 9, 9 to 11. This power comes to the court under Article 143, sub-article 2. I'll read that to you. Subject to the provisions of clause 3, rules made under this court may fix the minimum number of judges who are to sit for any purpose and may provide for the powers of the single judges and division courts. 3. The minimum number of judges who are to sit for the purpose of deciding any case involving a substantial question of law as to the interpretation of this Constitution for the purposes of hearing any reference under 143 shall not be less than 5. This becomes the keystone or the guiding factor under which we constitute constitution benches to decide issues. In the situation as it emanates today, all of you have been given a list of questions, a list of leading cases, which deal with the myriad jurisdictions of the law. These are essentially, the section I'm dealing with, are essentially questions of constitutional importance. Before we delve into the individual cases, there are certain things to be remembered when dealing with questions or leading cases, as the case may be. You see, there are 3 compartments in which the court works. The first is the Constitution itself. The Constitution has provisions. It has chapters, it has parts, it has schedules, it has additional powers which are framed. Now, for example, Schedule 1 to 10, the constitutional scheme per se itself, the divisions in various parts. Then that is the Constitution. The Constitution has to be maintained as a sacred document which forms the basis of all our rights, all the functioning of authorities, and most importantly, it compartmentalizes the issues of separation of power, which is one of the most important facets of any constitution, the checks and balances systems. The next we come to, and what the court does, is constitutional laws. It lays down the laws while interpreting it. It often goes beyond jurisdiction. It sometimes steps back and says, no, it's not my job. This is for the legislature to decide. We can only recommend. And the last and most important, which is a pillar of democracy, is constitutionalism in itself. When you look at constitutionalism, the court is supposed to function within the constitutional ambits for the purposes of achieving the constitutional aims. The constitutional aims are essentially the preamble and the first part of the Constitution which deals with your rights. Please keep this in mind, and then we will move along to examine the judgments which come. The court has over the years decided many a issue, larger benches, smaller benches, bigger benches, different benches, views of courts, views of judges. They've been at variance, but interestingly, all this has moved together as one significant aspect of our Constitution in defending our rights. Let me now introduce you to the judgments as they stand. The magnum opus of the Constitution, judgments of the court, is Kesav Nanda Bharti. Now, Kesav Nanda Bharti began as a very small matter with regard to the challenge to the Kerala Land Reforms Act of 1965, as also some other acts. The question which was referred to the Constitution bench was, does the amendment of the Constitution enable Parliament to abrogate or take away fundamental rights so as to destroy its identity? That was the essence of Kesav Nanda Bharti. Now the court examines this. It looks into the previous law in Golaknath. It looks into a whole host of cases. And then, after deliberation, it takes the view, no, Article 368 can be used by Parliament, but it cannot abrogate the fundamental rights. By a slender majority of 7:6, this principle was propounded by the court. It says, all these laws are good, but you cannot divert from the constitutional mandate of protecting the rights which are available to the citizens under Part 3 of the Constitution and some other articles of the Constitution which say that a citizen has a basic right, minority rights, individual rights, Article 21 rights, and the power to amend is not absolute. It is limited to judicial review where the need arises. Keeping in view Kesav Nanda Bharti, I'm giving you very short summaries because all of you will be reading on your own. I'm only introducing you to the judgments as you will find convenient to understand. Kesav Nanda Bharti has now become the keystone for testing any legislation or state action. It has been followed time and again in a plethora of cases, and as we go along, I will refer them. Kesav Nanda Bharti then is followed in Minerva Mills. Minerva Mills considers the amendment to the Constitution and the power of review as it came about in the in the amendments where sections 4 and 5 amended Article 31C. Article 31C says you can make legislation which cannot be challenged by two of the corners of this. And I want to read this to you because it will be of some significance as we go along. I want to read that one single part of Minerva Mills, which is very well written, so that you will understand what was said with the court. The court says, it is needless to cite decisions. I'm reading page 250, placetum F and G of Minerva Mills. It is needless to cite decisions which have extolled and upheld the personal freedoms, their majesty, and in certain circumstances their inviolability. It may, however, be profitable to see how the courts dealing with a broadly comparable constitution has approached the claim for freedom, while striking down the provisions of the amended 31C. This is what the majority says. I am emphasizing on this because it gives you an instinct into what the thinking of the court was in those days. It says Section 4 of the Constitution, 42nd Amendment, at page 263. I'm marking it for you. 263 says, Section 4 of the Constitution, 42nd Amendment, is beyond the amending power of the Parliament and is void, since it damages the basic or essential features of the Constitution and destroys its basic structure by a total exclusion of challenge to any law on the ground that it is inconsistent with or takes away or abridges any of the rights conferred by Article 14 or 19. If the law is for giving effect to the policy of the state towards securing all or any of the principles laid down in Part 4. There's an interesting observation by the court which says the Constitution rights are not mere adornments, they are authorities to the citizens. Please remember, Kesav Nanda Bharti is then amplified in Minerva Mills. Minerva Mills gives you an excellent guidance into what Kesav Nanda Bharti has decided. We then move, because if fundamental rights are taken away, they are not mere adornments. They are essential rights and basic rights of the people. Now, there is a competing interest between the legislature and the citizen. If there is a competing interest, which is in the larger interest of the citizen, it has to be protected. Therefore, the court struck down 31C and said, no, you may have legislative powers, but you cannot possibly go into this. They go on to say that 14, 19, and 21 stand between, mark the words, 14, 19, and 21 stand between the heaven of freedom and the abyss of unrestrained power. Article 31C has removed two sides of the golden triangle, which assures the people the preserve held forth by the promise held forth by the promise held forth by the preamble, because that is the essence of your constitution. So therefore, you move from the diversity of views in Kesav Nanda Bharti to the specific views in Minerva Mills. Why is it this? Why does this happen? After Kesav Nanda Bharti, after Minerva Mills, you have a plethora of judgments which come into this. One of them, which is very interesting and which you will find in your set of questions, is on the insertion of Article 15 in Paramati education. Paramati is serial number 33 of the list of judgments. I will touch upon all these as we go along. Paramati deals with the insertion of Article 5, Clause 5 in Article 15. How it goes about it, what it does, we will have a look in a bit. Then you read this with the judgment of Coelho, I.R. Coelho, which is serial number 23 in 2007, where it deals with the 9th schedule. What are the powers of governance to bring acts into the purview of the 9th schedule after the amendment of the 9th schedule? So the 9th schedule is amended. It brought into it the power to grant absolute immunity to legislation. The Supreme Court deals with it on the cornerstone of the basic rights of people. Then with this one, you'll make a note of Coelho, and then we will look at two other judgments, but not dealing with this directly, but it indirectly touches upon it. Those are the judgments in later points of time. You will also find a reference in Roger Matthews. Roger Matthews is serial number 55 of the list of judgments which you have. Now, look at these, and I will deal with each of these cases individually. Let's look at Coelho first. Coelho says, and yet please keep the Constitution next to you, gentlemen. It will help you in understanding. Just pick up the Constitution. See, if you see the ninth schedule, it is framed under Article 31B. The power of legislation is under 31B. Let's look at 31B. 31B says, validation of acts and regulations. It starts not with a non-obstante clause. It starts with without prejudice to the generality. None of the acts and regulations specified in the ninth schedule, nor any of the provisions thereof, shall be deemed to be void or ever to have become void on the ground that such act, regulation, or provision is inconsistent with or takes away or abridges any of the rights conferred by any of the provisions of this part. Now, this is amended with effect from 18 June 51, and then there are amendments which come into this. The amendment comes also in 1973, 24th April 73, when the Supreme Court examines it in Coelho. It says the 34th Amendment and the like was placed in the schedule. So therefore, when you place items to the schedule, you put it beyond the pale of challenge. What does the court do? Court considers this and says, no, this is an abridgment of fundamental rights because these things affect the impact and impact the part 3 of the Constitution. If you put an act to be a situation where it cannot be challenged, it is then incorrect. It is impermissible in law. Therefore, the court says, we will only look into those acts which are before 73, acts after 73 we will reconsider. So Coelho has a very significant status with regard to inclusion and prevention of challenges to statutory provisions included in the 9th schedule after the 24th of April 73. It says you cannot insert any and all acts within the purview of the 9th schedule because they grant an immunity to challenge. If you grant them an immunity to challenge, you take away fundamental rights. Hence, the insertion of these into the 9th schedule is per se incorrect, untenable, and unacceptable. The doctrine in Coelho has also been touched upon in subsequent cases. I will not give you the particulars. Please read them for yourself because then you will get a clearer perception of what Coelho, read with Minerva Mills, have had to say on this aspect. The courts have taken views, but essentially they've said the 9th schedule has to be read down. We now come to the second aspect of your paper, and that is the question of reservations. The first major judgment on reservation comes in Indira Sani, serial number 7. You will also read Indira Sani with Jarnail Singh, serial number 49. You will also touch upon it, the views expressed. Well, I won't confuse you. I will say put 7 and 49 together because that deals, those are the two of the questions, two of the leading cases which are there on reservations. Now, Indira Ghani, as it's called the famous Mandal case, there are several judgments which have been written by the judges. The dissent is by Kuldeep Singh. He takes a view which is contrary to the others. But essentially, it says that there is a national commission for the purposes of the scheduled castes and scheduled tribes, which has been established under Article 338. It has its duties and functions. It makes recommendations. The recommendations made should not come within the ambit and scope of the court if the recommendations have been made based on data and information. The court accepts the recommendations to an extent and remits some back to the government. Now, what is important is the interpretation it gives to Article 16, sub-Article 4. Please see 16.4. 16.4 becomes a keystone in deciding this. 16 says equality of opportunities of public employment. Court says nothing in this article should prevent the state from making any provision for the reservation of appointments or posts in favor of any backward class of citizens, which in the opinion of the state is not adequately represented. This is discussed in two cases after this. One, as I said, is Judicial, and the other is in Paramati. Paramati is the judgment which is at serial number. Just give me a minute. Correct. Yes, number 33 of your list of judgments. So you will find Indrasani, you will find Paramati or Paramati, and you will find Judicial, which deals with these issues of reservations. In Indira Gandhi, in Indrasani, the question is whether 16.4 is an exception to subclause 1 of Article 16. The view is, insofar as court is concerned, it brings it in the purview of Article 16 a new concept, economic backwardness, which is dealt with in Judicial, the creamy layer concept. Questions which arise in the larger constitutional conspectus is, it is very right for you to bring in new layers and new positions. This is a thought. I am putting these thoughts to you because you're all candidates. You must deliberate over them. The question which crosses my mind is, when the Constitution was first framed, reservations were limited to 50 years. They have been extended. Indrasani extends it. Question is, once there's a constitutional mandate to get rid of untouchability and other limits, can the courts extend this period? Can parliamentary legislation do this? Does it not defeat merit, which was the intent of the parliamentary makers, of the constitutional framers? After all, courts have jurisdiction to expand upon situations, but can you expand it to a manner which is difficult to accept when Constitution has specific mandate? Now, immediately to this, we come to the second aspect as to judicial legislation with regard to rights. You will find here, rights have been discussed in the euthanasia case, serial number 44, common cause. You will also find rights to be discussed in the case of Justice Puttaswamy, right of privacy. You will also find rights to have been discussed. Puttaswamy, I'll give you the serial number. That is number 43, right to privacy. You will also find reference to rights and creating a new class of people in the National Legal Services, serial number 32, when transgenders are recognized to be a class by themselves. This is by judicial interpretation of Article 14, 16, 19, and 21, that transgenders are also a group of people entitled to equal rights. Look at the beautiful way the court has proceeded. It grants you rights. It expands on your rights in Puttaswamy. It expands on your rights in a big way in the legal services case. It amplifies the rights of in common cause, the euthanasia case, serial number 44, which says the right to die in the case of terminally ill patients with no hope of recovery is available to them. Draws a distinction between the sphere of individual liberties and what is to be done in such circumstances. The question which I pose in thinking on this issue, it's not a grain of the constitutional judgment, but just a personal view. Don't you support suicide by this? You have a right to die. You have a constitutional protection to your fundamental rights. You have a right to choose what you want to do. But if you choose to die, isn't it suicide? This is where the balance has to come. It has been discussed. Please look into it. What is the right to die? What is the right to live? This is also touched upon to an extent in the national legal services situation, where transgenders were expelled from society, how the court brought in their rights. So if you read this as a fascinating study, you will find that the court has gone into judicial legislation by judicial interpretation to give rights in a very large way in the constitutional scheme, which may have been omitted or not read into the first foundations of the Constitution. Article 19 does not have many rights, which the court reads into it. Euthanasia is one, privacy is one, your protection in the Aadhaar case, Puttaswamy, the second case, your protections in various other matters. So therefore, look at the constitutional scheme not by reading and leading judgment individually, but as a conspectus of what the law has to say. That is where the interest becomes far more than you can possibly understand. After all, you're all gentlemen, you're all participating to be advocates in record. The ethos of the court has to come into your systems. You've got to understand how the court functions. What's its functionality? What's its constitutional duties? How it works? How it is supposed to be discharging its functions. We now come to another issue which has become of great significance in the recent times, and that is the powers of legislation in the matters of administration of tribunals, money bills, and the like. I will keep one topic for the end, but here I want to touch upon Roger Matthews. Roger Matthews is 55. Roger Matthews, the rules framed under the Finance Act are struck down by saying, no, you cannot do this under the money bill. But it reserves powers to Parliament on the money bill, but refers the question of the money bill and powers to a larger bench. Roger Matthews is a dichotomy. It touches upon the rights of Parliament. I use the word rights. I should say jurisdiction and power of Parliament to legislate and finance bills under Article 110. But can you read that power to control finances and regulations of courts and tribunals, which are totally separate and constituted under a specific provision of the Constitution? Court says no. You cannot frame rules for these because these are totally separate and independent. They have a specific provision within the framework of the Constitution. It is here that the doctrine of separation of power comes in. You have separate jurisdictions under the Constitution. Please follow them, please protect them, and please use your powers for the furtherance of the purposes of the Constitution. Now I come to the last topic because we have been given timelines, and that is the 10th schedule. The first major case on the 10th schedule is Kehote Holohan. That's a Constitution bench at serial number 6. The next case in this is Rameshwar Prasad, serial number 22. And the third case, which touches upon these powers, is the very recent decision of Justice Nariman in Keshav Singh, which is item number 59. Let us see these three cases which deal with the 10th schedule. Now please see the 10th schedule and when it was inserted. Please pick up your constitutions, have a look at the 10th schedule. The 10th schedule comes into force by an amendment, the 52nd Amendment. The purpose of this is to stop horse trading, to prevent a breakdown of the democratic election process. The government framed and inserted the 10th schedule to say, look, this business of people walking from one party to the other and governments collapsing is not in the interest of democracy. So the question came to the Supreme Court, first in Kehote Holohan. Now, the court examines all this, but says everything is good about it excepting Part 7. Now, Part 7 deals with what? Part 7 of the 10th schedule says, notwithstanding anything in this constitution, no court shall have any jurisdiction in respect of any matter connected with the disqualification of a member of a house under this schedule. Court says, no, I'm sorry. Our powers of judicial review, which are protected by the Constitution and are a basic right of the people to invoke under 32 or 226, cannot be abridged. In Kyoto Holohan, they go to an extent of saying this power of judicial review is sacrosanct, especially in such matters which affect public morality. If that is the view of the court, which has been followed, now just pick up, you won't have it, but I'll just tell you in Kyoto Holohan, you see para 110, just for your reference. Kyoto Holohan, para 110, will give you an idea as to what the court has to say. It is here that the court follows the rules of construction and judicial review. It brings in the powers of the court for the purposes of examining the correctness or otherwise of the legislative decision of the Speaker. Has he followed natural justice? Has he gone by principles? So the decision of the Speaker, which could not be challenged, is now open to challenge, leaving a large number of questions which arise. If you see the last judgment on this, the Manipur Speaker Assembly case, it says that insofar as Kyoto Holohan is concerned, it leaves it to Parliament to have a rethink to substantiate, to substitute the Speaker of the Lok Sabha, or the Legislative Assembly, as arbiters. Now, if you are going to say that the Speaker of the House, of the respective houses, and their powers are to be considered as arbiters, it is a very odd statement to my mind, because that's a constitutional provision. If you have doubts about their powers, you should have struck it down. Why refer it back to Parliament? If in the perception of your judicial review by 3 judges, please mark 3 judges, not 5. It's a constitutional question. 3 judges now remark, no, this provision needs to be relooked at. When this very provision has been upheld by a larger bench, both in Kehote as well as in Rameshwar Prasad, how do 3 judges take the view that this requires a rethink? Rethink, reference are matters which have been debated and discussed, and the procedures have been laid down for referring it to larger benches. You cannot possibly take this view. This is my perception, because it goes to a very important issue of parliamentary practice. It goes to a vital issue of judicial review. You've got to look at situations as they emanate, not on facts, but on a constitutional perspective. Here, the court refers to the quatimit doctrine. If you look at quatimit, and I'll read it to you for your information. Just see quatimit in the Manipur judgment. Quatimit is set out in the judgment in para 26. It relies on foreign judgments, and it relies on the principles of torts. It relies on judgments in which is a bill in equity. Now, these are not bills in equity. These are constitutional provisions framed by Parliament which have been upheld by the court. So, have a look at these. You will enjoy the reading, and I hope you all will do well in the oncoming examination. My purpose was to give you a perspective in the short 45 minutes to introduce you to the constitutional practice, judicial review, constitutional practice, constitutional mandates, and the powers of the court as available in the framework of our Constitution. If you have any questions, I'm open to them. Thank you. You are all open to ask any questions that you want. You have 5 minutes, that's my limitation. Please open up the. Please unmute everybody.
Sir.
Let them all ask questions. They're more than open. I have how much to write in one judgment? Well, that's your choice, isn't it, Pinky? Pinky Agarwal, your question. Already put them on the chat. I'll answer them for you. Pinky Agarwal's question is, how much do we write in a judgment? You write what you know. Make it as clear and crisp as you can. Karan Kaushik is asking me, Shilpa, what is expected? Now, just go one by one. Gitanjali, how do we frame answers? What is expected? That's the question I put to you. We have put the questions, you frame your answers. You look at what you know, you incorporate them. Then we have questions. Don't delete them, let them roll on the questions, please. Suresh Kumar. Let the questions come, please, on the chat. They're getting deleted. Yes. Can I know the pattern of the question paper? No, sorry, you can't. We don't set them. They're set by a committee which is not ours. We are only here to lecture you. Then do Karanjit Singh. Why did the court want to give? Please don't delete so fast. I'm not able to read. Navdeep, what is the question? You know, you don't have to, you can write the questions which are there by referring to the judgments. If you want to dilate on them, you may. How to know the ratio of the judgment? Are they so lengthy? Well, the judgments are supposed to be read. They are lengthy. We also read them. That is how we learn. So you must understand to look into it. How important is it to read the? It is very important to read the complete judgment, because in the complete judgment you get ratios, you get everything else. Please provide some hint as to what area we can focus more. No hint was given yesterday. How can we give you a hint on what the questions are, friend? Those are questions which come from the court. That's something which we also possibly have no comment to offer you. How number of questions to be asked? What will I write apart from facts and business? You will write the law. Suresh Kumar. Please go slowly on the questions, please. I am not able to respond. When there. Can you click on chat button that? Let's just go slow on the scroll here. Gentlemen, controllers, just go slow on the scroll, because I've got to answer questions these youngsters are asking me. Kindly advise what is the format, facts, judgment, etc. See that you will have to see the question. TV, question of law. Why did the court? Oh God. Punita Singh. How should we structure the answer? That's your choice. Gurinder Singh, give us a model answer. How can I give you a model answer when I don't have a question? Any documents for sharing? Megha Singh, do we need to analyze the majority? Yes, you must analyze the majority. You must support it with your views as to why it is right or wrong. Can one write? Rajesh Kumar, no, wow. Tani, look, this is scrolling too fast for us to answer. You should write your answers as briefly and as correctly as possible. Should we write a paragraph verbatim? No, you must write in your own language. You are a fool to conduct. What is this? Can we criticize the judgment? Total number of questions. I have no idea. Total number of questions. I have no answer. We receive head notes. What is the head notes? Only introduces you to the judgment. Can you please, Srishti Chatterjee, will any notes be shared? I have no, I mean, you can ask me questions informally. I will answer your questions, whatever you want. Shivang, documents, is the citation necessary? Yes, it is. Tanya Agarwal, advocate, can you, as discussed, please just the case number. I'll give it to you. Tanya, call me up. I'll give it to you. Please share email WebEx that chat has issued. I have no idea. And Kashyap, can you please give us a list on all the cases? Can recent judgments will? No, the 64 questions will constitute the basics of the paper. If you want to add, please add your knowledge, because if you add more questions, it will show you that you have read. Will we be supplied? I have no idea about what will be supplied, what journals will be supplied. That's for the examiners committee. Why did the court that went ahead to give directions in Vishakha and Nalsa cases? Now that Vishakha and Nalsa is not a part of your, is a part of municipal law. Can we get your notes? Well, I have done it verbatim. I mean, I've done it extempo. So you can listen to this on the YouTube again. How much time will we get? Roger Matthews is to be read. Yes, it has to be read with Madras because Matthews 2011 Madras is referred to in Roger Matthews. It is one of the judgments and citations with Roger Matthews. List of all the cases discussed. I have discussed the cases on the constitutional issues. You want the numbers, I'll give them to you. So that is the question and answer. I'm running out of time. I'm trying to do my best to answer all your questions. So this is it. If any of you have any questions on this, we are available to you. You can catch hold of us in the libraries. You can call me up. You can call us up. We are happy to help you and answer any questions which you have. Thank you and very nice to be with all of you. Good day.
Thank you, sir.
I am discontinuing the video and the mute. So you take over, please.
Kailash Vasudev sir, am I audible? Kailash Vasudev sir, am I audible, sir?
You're very audible.
Sir, please switch on your camera, sir.
Switched on.
Sir,
Someone has just asked me for hints to be an advocate on record. There are 3 hints. 1, get your drafting right. B, prepare your case law. And number 3, and most important, know the procedures of the court. There are no other hints we can give you because that's what we learned when we became advocates on record.
may I request Venugopal Sahab, sir, to please address this, sir.
I am now discontinuing my video and going mute.
Sir, so grateful, sir. Thank you.
Thank you. Thank you very much.
Okay, may I start?
Sir, please, by request, by all means, sir.
Okay, I wanted to start with, I am doing an assortment of cases that are not quite the same as what Mr. Vasudev has been dealing with. That is not on constitutional and other issues, but rather some miscellaneous cases on various commercial issues, regulatory issues, etc., etc. So let me begin with the Italian Marines case. This is Republic of Italy versus Union of India. You should find it in your list of cases. Now, the facts were that within India's contiguous zone, which is about 24 miles from the baseline, certain Italian Marines on board an Italian vessel fired upon an Indian fishing vessel and killed 2 persons. Thereafter, the state of Kerala started the criminal proceedings, filed an registered an FIR, started investigation, etc. That was challenged by way of a writ petition, and that in turn was carried to the Supreme Court by the Marines. In the meantime, the Republic of Italy had also initiated a proceeding before the Supreme Court, and the issue was who had jurisdiction, Union of India or the state of Kerala. After construing the provisions of the Maritime Zones, etc. Act of 76, in relation to the UN Convention on Law of the Sea, the Supreme Court basically held that it is only the Union of India which would have jurisdiction when it came to something in the contiguous zone. They said further that under the United Nations Convention on the Law of the Sea, Article 97 relating to incidents, which covers incidents related to navigation and collision, the flag state and the flag state would have jurisdiction, but that may not apply. At the same time, there is Article 100, which talks about piracy and how states must cooperate on piracy. So they said all these issues are related to defenses that the Marines may take before the relevant court, where the Union of India said they have jurisdiction. And therefore, the facts have to be found in the trial. But they said the state would have no jurisdiction when the incident occurs within the contiguous zone. Only the union would. So that is one case. Let me then go to two Competition Act cases. One is Competition Commission of India versus Bharti Airtel. Now, in this case, basically Bharti Airtel and the incumbent operators, the dominant incumbent telecom operators, that is Vodafone and Idea Cellular, had challenged the action of the CCI under Section 26 of the Competition Act, initiating an investigation into an alleged agreement in violation of Section 3 of the Competition Act, right? Normally it applies to price fixing, cartels, etc. And it was Reliance, which at that time, if you remember, had started operations and wanted to get a foothold, where they felt that these incumbent operators were preventing them from really expanding their reach. So in that context, the question before the Supreme Court was, which regulator? Is it TRAI, Telecom Regulatory Authority of India, or CCI, which should have jurisdiction? And the court concluded that, at least at the initial stage, it should be the sectoral regulator, which would render findings of fact on various aspects, jurisdictional aspects, and only after that would the CCI go into the issue of whether or not there was a conspiracy by way of an agreement amongst the incumbent operators in relation to the requirements that they were required to follow under the TRAI Act. So very broadly, this judgment has been taken as precedent for only going into, that is, only the sectoral regulator must go into these competition issues first, because even they have got provisions relating to maintaining a fair, non-discriminatory and competitive market. Now, this would obviously apply even in the case of electricity, etc., wherever there is a sectoral regulator. So this is an important judgment. Then I'll turn to Excel Crop Care. Okay. Excel Crop Care is a case where 3 companies had been accused by Food Corporation of India of having conspired to fix prices in tenders by FCI for something called aluminum phosphide tablets, which they needed to preserve the grain that they procure. So in the context of during this investigation, CCI found that these parties had in fact colluded to fix prices that they were offering and also engaged in a collusive boycott of a subsequent tender, which had caused serious adverse effects on competition. And this would be a per se, if there was evidence, it would be a per se violation of the competition, section 3 of the Competition Act. Adverse effects are presumed. So if they prove the conspiracy or the agreement, then adverse effects on competition would be presumed. Now, when the matter went to the Competition Appellate Tribunal, the Appellate Tribunal said, confirmed the CCI's order, the outcome, but said that the penalty imposed had been too high because it extended across all products that were being sold by the 3 companies. 2 out of the 3 companies especially were very diversified companies, that is United Phosphates and Excel Crop Care were diversified companies that had very large revenues from other products. So the Competition Appellate Tribunal said that the penalty in under Section 27 of the Act has to be confined to that is, the percentage of the turnover or the profits has to be confined to the relevant product in which they found a breach of the Competition Act, a violation or contravention of the Competition Act. That was carried up in appeal to the Supreme Court, and in its judgment, the Supreme Court applied the doctrine of proportionality to say that in essence, you could not extend the penalty across all products because the definition of an enterprise under the Competition Act is extremely broad. It would extend even to a whole conglomerate like, let's say, Tata's, which has multiple lines of business, multiple companies, all of which are affiliated and in which Tata Sons owns significant shares, right? So the Supreme Court said that this is highly disproportionate as a penalty and therefore confined it to the product in respect of which a contravention was found. And they confirmed the order of the CCI and the compact that there in fact had been a conspiracy to fix prices. Now, I wanted to mention one aspect that all of you should know. Subsequent to that, now the Parliament has passed an amendment to the Act and added an explanation 2 to Section 27(1), which basically seeks to legislatively overrule this finding of the Supreme Court by saying that turnover would be turnover of the entire enterprise. So, a global turnover of the entire enterprise. So we'll have to wait and see how this turns out if the constitutionality is challenged. Then let me come to another interesting issue. This is the powers of the RBI to regulate virtual currency in the Internet and Mobile Association of India judgment. Here, there was a challenge by certain virtual currency, an association representing virtual currency exchanges, that is the Internet and Mobile Association of India, where a challenge to an RBI statement on development and regulatory policies, as well as a circular dated 6th of April 2018, where they essentially said that all regulated entities shall ensure that they do not deal in or provide services to any individual or business entity dealing in virtual currency. This was challenged before the Supreme Court on various grounds, including that the RBI's power did not extend to regulating virtual currencies. The Supreme Court, however, held that because the RBI's mandate is extremely wide, even if virtual currencies cannot be treated as legal tender, even then the RBI's mandate is to ensure stability of the currency, etc., which would certainly include these aspects, that is, virtual currencies, to the extent that they're being used to transact in various commodities. In the real world, virtual currency can be used to buy and sell anything, services, goods, etc., and therefore the RBI's mandate to ensure stability of the currency and to conduct monetary policy, etc., would necessarily be affected. However, the Supreme Court set aside the ban, the complete ban, saying that there was no evidence to show that that is, even the RBI had not rendered any findings until then that there was a serious problem with that is, there was a serious impact of virtual currencies on the stability of the currency, etc. And therefore, they struck it down on the ground of the doctrine of proportionality. They said that therefore the circular would be struck down on that ground. That is, the RBI has the power, but it had not showed that it was necessary to ban all dealings with them. And to this day, I think there is confusion as to whether cryptocurrencies and virtual currencies like Bitcoin are legal or not legal. Right? So now let me turn to another case. This one is Dheeraj More. The Constitution bench here was dealing with a challenge by judicial officers to the rules of various states whereby they were being excluded from competing in the category of advocates with 7 years of practice for appointment as district judges. So judicial officers felt that if they had been appointed after 7 years of practicing as an advocate, then they could not be excluded. They also said that their service as judges ought to be respected and they should be allowed to compete in these or for these positions. However, the Supreme Court held that Article 233 of the Constitution certainly did not contemplate that serving judicial officers could be applying for the position. The plurality, that is, two judges held that, that is, Justice Arun Mishra, writing for the bench, held that Article 233 only contemplated practicing advocates who had completed 7 years of service. And there was a concurring opinion by Justice Butt saying that Article 33 has to be interpreted in that manner only. So therefore, as far as judicial officers were concerned, they could only be considered for the post of district judge by promotion in terms of rules made under Article 234 and under the proviso to Article 309. Next, let me deal with the judgment in CPIO, Supreme Court of India versus Subhash Chandra. This was a case where some activists had applied for information, that is, Subhash Chandra Agarwal had applied for information under various heads. in relation to judges. One issue was he wanted to know all about the assets of serving judges. And the issue was whether serving judges are entitled to keep this information confidential under the exception in section 81J of the Right to Information Act, which deals with fiduciary relationships. So they are disclosing to the Supreme Court would be the issue. They are disclosing to the Supreme Court, which must keep this information on their assets confidential. The second issue was of persons who are being considered for elevation and judicial appointments. Can they be, can all the correspondence between the government, between the High Court and Supreme Court, etc., can all of that be, and file notings, can all that be revealed under the Right to Information Act as sought for by the respondent? Now, in this case, the Supreme Court held that the right to know, the right to privacy, transparency, accountability, and independence of the judiciary have to be balanced, and that judges could not claim any right to maintain their assets as being confidential, that it did not impinge on the right to independence of the judiciary, etc., if their information on their assets was revealed under the Right to Information Act. On the other hand, in relation to the appointment of judges, the Supreme Court held that you cannot have a situation in which all this correspondence, etc., and file notings are made public. It impinges on the independence of the judiciary, and it will affect the right to privacy of candidates, etc. I'll turn now to the Arbitration Act. I'm sorry, I'm just checking. No, I'm sorry, I can't give you hints like that. My advice to all of you is please read every judgment and understand it broadly in terms of the ratio, and please follow whatever I'm talking about. It will all be helpful to you in the end. So this is all that I can say in this regard. 64 cases is not a very big issue. I can't tell you the pattern of the question paper, etc. What I can tell you is that if you haven't read the judgments and understood them before you enter the exam hall, you may find this paper difficult. Okay, so it's important that you do read and understand. My suggestion is that you need to understand the majority and minority views. However, there will be definitely more weight placed upon understanding, having understood the arguments and the ratio of the majority in most judgments. Okay. So the questions are such that obviously if you show that you have read and understood the judgments, both majority and minority, I believe that the examiners would be more happy with you. I'm not going to provide any more details about the question paper. Now I'm going to go to the Sangyong case. So yes, my advice to you is read and understand each of the 64 judgments, because you will be tested fairly broadly. So please don't restrict yourself in terms of what you read and understand. Okay, that much of a hint I can give you. The issue of what will be supplied to you in the examination hall, kindly ask the AOR examination cell. I am not competent to tell you. So now I'm turning to the last question, which is Sangyong. That is the arbitration judgment. I'm assuming all of you know what the Sangyong case was about. Essentially, it was a challenge to an award in an international commercial arbitration involving NHAI on one side and a Korean company, Sangyong, on the other. So, as you are probably aware, the standards for challenging an international commercial arbitration under the Arbitration Act are slightly different from the standards in the from the grounds in the case of a domestic arbitration, and I'm talking about Section 34. Now, the Act itself, all of you may recall, had been amended fairly extensively, especially in Section 34, after in 2015, right? So in Sangyong, the Supreme Court was dealing with the issue of when the amendment would apply, and they clearly held that Section 34 applications made after the date of the amendment would be governed by the new amended Act. And they held that it can't be that merely because of a clarification, one part of it is a clarification and another part is not, that therefore it would be treated as being retrospective. They held that you have to read it as a whole, and it will be prospective in the sense that a 34 application filed after the date of the amendment will be governed by the amended Act. Now, the other important aspect of Sangyong is that Justice Nariman clarified the grounds for challenge after associated builders, because of the amendments to the Act. And it's quite interesting because he clarifies what is perversity in a judgment. And interestingly, unlike in associated builders, where he had talked about perversity as being reaching a conclusion. I need the charger. This is not going to work. It's going to. Just one moment. I'm sorry. I'm having some technical issue. No, this won't work. I need the. Yeah, that's the one. Sorry. I'm so sorry. Yeah, sorry. So, unlike in associated builders, this is a very interesting aspect where he said that perversity would also include the test of whether a reasonable person could have come to that conclusion, or it was so irrational that no reasonable person could come to that conclusion. You will find in Sangyong that that is altered now to talk only in relation to evidence. Whether the arbitral tribunal had ignored, whether there was no evidence at all to support a conclusion of the arbitrator. The second point was that the arbitrator had ignored vital evidence. Or third, the arbitrator had taken evidence into account behind the back of one of the parties. That is, some evidence was let into the record without letting the other party know. And on interpretation of the contract, he held that it would be perverse if this was a completely unreasonable, that it was a view on interpretation taken by the tribunal was completely impossible or implausible to the point where no alternative, that is the correct interpretation, had been completely eschewed, right? So that becomes the standard now for patent illegality. One more interesting aspect was he held that as far as being contrary to notions of, as far as being contrary to public policy was concerned, he held that it is only where something, or rather, where you would say that something contravenes justice and notions of morality as per the explanation that was added in 2015, is where something shocks the conscience of the court. And he clarified that mere contravention of the substantive laws of India would not constitute patent illegality or be contrary to public policy. So this is another fairly useful thing to keep in mind after SsangYong, that just because something contravenes the substantive law of India, it is not a ground. Okay. Now, let me, is there anything else that I should be saying? Now, let me move on to the next question, next case. I wanted to discuss Kailash Nath. Kailash Nath arose out of an auction conducted by DDA for property where it appears that the appellant had given an earnest money deposit. But DDA went ahead and cancelled the auction and then proceeded to sell that property for a very high price to a third party. They also forfeited the earnest money given by this appellant. The appellant had filed a suit for specific performance, and in that context, the dispute came before the Supreme Court, and the Supreme Court discussed in extenso the principles applicable to award of damages under section 73 and 74, applied the old law, explained the old law in Mawla Baksh, etc., and then pointed out that you cannot, as held in Mawla Baksh and that line of judgments, you cannot award damages where loss has not been proved, and that would include earnest money. However, in this case, they said that section 73 and 74 of the Contract Act would not apply because there was no concluded contract between the appellant and DDA. It was only a case of forfeiture of earnest money at the auction stage before the contract had been concluded. They applied Article 14 and said that DDA could not forfeit the earnest money because DDA did not suffer any loss. And moreover, they did not find that Kailash Nath had breached any of the requirements. So that is Kailash Nath's case. It is an important judgment because it summarizes the law on 73 and 74, though ultimately it held that 73 and 74 would not apply in such a case. Yes, I must tell you one interesting aspect of the DMRC case. Now, this is my personal view. I think the curative bench presided over by the Chief Justice was quite shocked at the award of 8,000 crores in favor of Reliance Infrastructure Limited, which is, I believe, an Anil Ambani company, and against Delhi Metro. They, I think, were not impressed with the findings of the arbitral tribunal, which had consisted of experts. The DMRC judgment is very useful because it represents the latest, largest bench judgment on the grounds that are applicable under Section 34, though ultimately they said there had been a grave miscarriage of justice for purposes of whether it fell in the curative jurisdiction. You may recall that there was a lot of confusion over whether curatives can at all apply in a commercial case. And various experts felt DMRC, I don't believe, is part of your 64 cases. I'm only telling you because it may be useful to you in the event that you are dealing with any question relating to arbitration. And the review and curative jurisdiction also, the DMRC case would be extremely important, right? Now, I suspect somebody else has given you a lecture on Hurrah's case, but if you have read Hurrah's case, that leads to some confusion because it talks of a breach of natural justice or other like ground. And people have largely ignored the fact that the judgment also allows the Supreme Court to correct a judgment through a curative where there is a larger head under which natural justice falls. That is a grave miscarriage of justice, right? So DMRC is important because in relation to Hurrah's case, it clarifies that where there is a grave miscarriage of justice, the Supreme Court can intervene, all right? But the interesting aspect of DMRC on arbitration, for what it's worth, is that it has summarized the entire law relating to the grounds on which a court may interfere under Section 34, and it includes the ground of perversity, that is, no reasonable man could reach a particular conclusion, which is there and associated, but has been left out either knowingly or unknowingly in Sangyong post-amendment under the head of patent illegality. And I wanted to point out that both DMRC and Sangyong deal with post-2015 amendment section 34s. In fact, in DMRC, the award had come in 2017. So it's not just the section 34, even the award itself was after the 2015 amendments. Let me now turn to okay, I'm not dealing with reviews and curatives and the LGBT community, etc. That's not within my remit. I believe one of the other lecturers must have talked to you about curatives and Hurrah, etc. And the constitutional cases dealing with Article 21, etc. So you please sort of go by that. Now, I noticed there's a question on the DMRC case in the context of 34. I just told you that if you read the DMRC case, it summarizes beautifully the entire law on when you can challenge an award under the head of especially of patent illegality. It summarizes the law up to now and includes what was said in associated, though Sangyong, in Sangyong, Justice Nariman did not include that head of a conclusion that no reasonable man could have arrived at in dealing with patent illegality. So that's what I had to say on Sangyong and arbitration. Now let me turn to Gujarat MCO. This judgment is on PPAs and the power of the electricity regulators, that is the state electricity regulatory commissions. The issue is somewhat complicated and arcane, but it related to whether a party can get accelerated depreciation under a clause in the PPA, even though he did not supply electricity during the control period. And this is under the Income Tax Act, of course, accelerated depreciation under the under the Income Tax Act. Now, what is interesting here is that the court set aside the tariff order when it was challenged by Gujarat Urja Vikas Nigam, which is the distributor. The court set aside the order of the regulator, that is the Gujarat State Electricity Regulatory Commission, because it had allowed this benefit to the party, that is to the generator, in violation of the PPA. The court holds that the PPA, that is the power purchase agreement, is binding on the regulator and has to be strictly followed by the regulator as well as by the parties. So that is the effect of MCO. Now let me go to two judgments under the IBC. Swiss Ribbons, which was delivered in 2019, I believe, or late 2018, by Justice Nariman again, involved a constitutional challenge to the validity of various provisions of the Insolvency and Bankruptcy Court, the code. There was an attack on various aspects, out of which I consider three to be quite important. One is that a challenge saying that the provisions of the code treat financial creditors very differently from operational creditors, even though there are no intelligible differentia. Why should the operational creditor be required to adduce evidence of default, etc., when the financial creditor need do why should he issue notice of default, etc., as provided for under the code read with the regulations, when he could easily do exactly what a financial creditor does, that he simply produces the evidence that the debt is owed, there is a default, and then you go ahead and initiate insolvency if you find that these requirements are met under Section 7. On the other hand, in the case of the operational creditor, after he issues the notice, there is a response by the debtor, corporate debtor, and then the tribunal is required to go into a defense that may be raised by the debtor as to whether or not there was a prior dispute, which is not there in the case of financial creditors. And Justice Nariman holds that there are intelligible differentia between the two categories. Financial creditors have much greater knowledge about the company, etc., etc., have got much better understanding of the financial issues that are involved and so on, and therefore there are intelligible differentia between yeah, I'm discussing Swiss Ribbons only. I'm looking at the comments and trying to clarify as I go along. So Justice Nariman holds there are intelligible differentia between the two categories. Therefore, there is no harm at all in providing for two different modes of initiating insolvency petitions and so on. There was also an attack on the role of information utilities. You may recall that under the provisions of the code, especially Section 7, they are required to look into whether or not the debt is owed. They wanted to mention serial numbers before discussing. I'm giving you the name, you can, is it correct that you have not been able to hear me? Please type into your chat box. Oh, okay. Then who is saying they can't hear me? Okay, I think it is the computer of the person who is is complaining. Okay, all right. My apologies. Let me go on. Now, the Yeah, there's you may recall that under Section 7, if you see Section 7 of the Act, the evidence of the debt in the records of an information utility is considered to be almost probative of the debt. Now, the issue of whether private information utilities, I'm discussing now, Ms. Aditi Gupta, I'm now discussing the second challenge, which was to the special role assigned to information utilities. The challenge was that there are private information utilities which may have their own incentives to say that a debt is owed, etc. I'm sorry, Mr. Guninder or Ms. Guninder. I can't really help it. I will now try to give you as I'm going along. I'll give you. Why don't we try this? Since I don't want to waste my time right now hunting for the number of the case, I will tell you which case I'm on, and then you people tell me when you have found it. Whoever says first that they found it, I will go by that and discuss the case after that. I hope that's okay. Okay, so this was the second major challenge, but the court brushed aside that challenge, saying that the role of information utilities also is fine. It doesn't violate anything. The fact that the information utility may be private is neither here nor there. The third challenge which I wanted to bring to your attention is the attack on Section 29 capital A of the Act, which was introduced by amendment. You may all remember that sometime during the Chitra Sharma case concerning the insolvency of JP Infratech Limited, the government brought in an amendment to say that the ex-promoters cannot be allowed to provide a resolution plan if they have been willful defaulters, etc. And the definition also of who all are related has been extended. So this also was challenged, and Justice Nariman has upheld the provisions of the Act in Section 29A as well as being perfectly valid, not unreasonable, and not arbitrary, because the Parliament is entitled to say that they want to exclude a class of promoters who have been willful defaulters, because that can have various consequences. The third aspect is the challenge to Section 53, which is the distribution of the proceeds from the liquidation estate amongst various categories of creditors. Justice Nariman has upheld the priority section as well as being perfectly reasonable and reasonable classification of various categories. Now, this arises primarily because after CIRP costs, secured creditors would have the priority over everybody else. There's CIRP creditors and then workman's dues for a period of 2 years plus secured creditors have got priority over everybody else. And normally, as you know, in most insolvencies, the banks and financial institutions which have a security interest in the assets of the corporate debtor would have lent far more than the value of the liquidation estate. Yes, you are right. Promoters who are of MSMEs are allowed to put in a resolution plan and are exempt from the bar under Section 29 capital A. Huh? And that is because nobody else, they feel, would bid for an MSME. So they felt that they needed to enlarge the pool, and that is how MSMEs are allowed to, MSME promoters are allowed to put in a bid. that is micro, small, and medium, micro, medium, and small enterprises, whatever. Micro, small, and medium enterprises, right? So the priority provision also has been upheld. And incidentally, if you look at the priority provision, it largely parallels what is there under the old Companies Act, the 1956 Act and the 2013 Act as well. So that has also been upheld. Then comes the SR judgment. Now, this was a challenge by the ex-promoters, etc., to the resolution plan, and there were numerous questions which were dealt with in this judgment, again by Justice Nariman. One of the very important issues is the grounds on which a plan can be challenged. Now, some of you may recall that in the Shashidhar judgment, I think it was Justice Khanwilkar or Justice Maheshwari writing for the bench, in the Shashidhar judgment, the court made it clear that you can challenge, or the jurisdiction of the adjudicating authority is highly limited. If you read section 31(1) of the code, it limits the jurisdiction of the authority, adjudicating authority, that is NCLT, to the grounds which are set out in section 30, subsection 2 of the Act. And what is interesting about that provision is that these issues are supposed to be looked into by the resolution professional before presenting the plan to the committee of creditors. Now, the court in Shashidhar made a very broad, or rather a very precise demarcation of the remit of the adjudicating authority versus the committee of creditors. And this is important for all of you to know as part of the judgment in Shashidhar, which has been followed in SR with a slight modification. Basically, the adjudicating authority is confined to the issues set out in 30 subsection 2. Now, most of you may recall that 30 subsection 2b says that operational creditors would have to be paid in priority to the financial creditors to the extent that they are entitled to amounts under section 53 of the code. So in a sense, it's a kind of deeming fiction. Operational creditors and dissenting financial creditors are entitled to be paid in priority based on their entitlement under section 53. This is important for all of you to know. That is one ground, therefore, on which the plan can be challenged, that the plan does not provide for this. Then another very important ground which you should know, which is always used in most challenges to a plan, is 30 subsection 2e of the code, which is that the plan cannot contravene the provisions of the law for time being in force. That has been construed, not in Shashidhar, but in, I believe, by Justice Nariman in SR or some other judgment, as meaning, in SR itself, that as meaning that it cannot contravene the provisions of any law for the time being in force or the IBC. So a plan has to comply with the IBC and the regulations made under the IBC as well. So you would also know that in the appeal provision, in the challenge to the plan, material irregularities in procedure followed by the RP is also a ground. In the appeal procedure, in the appeal against the adjudicatory authority's decision approving the plan, this would be an additional ground. So this is something which has to be gone into by the adjudicating authority under section 31(1), right? as to whether the plan contravenes the provisions of the code or the regulations. But the other side of the divide is the commercial wisdom of the COC or the Committee of Creditors. The Committee of Creditors cannot go into, the adjudicating authority cannot go into the commercial wisdom of the Committee of Creditors, especially with respect to the feasibility and viability of the plan and the mode of distribution among the categories of financial creditors, right, including priority, right? Sorry. Now, one aspect is, which I'd like to clarify, and there's a very helpful question from somebody on the group, from Debal Priyo Bhattacharya. I'd like to clarify that the judgment also makes it clear in SR that if nothing is to be paid to operational creditors based on the liquidation value as per section 53, then that provision 32B would not operate in favor of the
extinguishment of personal guarantee.
right?
Documents and
Yes, yes. So therefore, operational creditors are entitled to priority in payment under the plan only to the extent that they are entitled to some part of the liquidation value under section 53. All right.
So when it says
Now, the modification. Okay, let me try to deal with some of the questions on the group. Yeah, so 32B provides for both categories. Operational creditors get first preference in terms of liquidation value payable to them under section 53 if there is some liquidation value left after giving it to the workmen and secured creditors, right? Now, dissenting financial creditors also get the same treatment. They are entitled to payment on priority in terms of the liquidation value. Now, dissenting financial creditors again can be of two types. One is secured dissenting financial creditors and the other is unsecured. If you're an unsecured financial creditor, then you are not entitled to priority. That is, you again would get only what is left over after the liquidation waterfall, the waterfall under section 63. All right, 53. My apologies. And so the commercial wisdom of the COC can't be interfered with by the adjudicating authority. This is important for you to know. Okay. Now, one aspect which Justice Nariman has clarified in his judgment in SR is that the adjudicating authority, while the adjudicating authority cannot interfere with the merits of the commercial wisdom, that he has put a gloss on what has been decided in Shashidhar. He says that the adjudicating authority needs to verify that the corporate debtor continues to be kept as a going concern during the insolvency resolution process. The second is that in fact, the value of the assets are being maximized, and that the interests of all stakeholders, including operational creditors, have been taken care of. Now, he has clarified that, for example, if there is an operational creditor who's a supplier to the company, the corporate debtor, and the plan makes absolutely no provision for paying such operational creditors in a manner where it would collapse, that certainly has to be kept in mind. But I must tell you that subsequent judgments have not really gone on this footing. I don't believe there is any decided case where they've actually interpreted these aspects of SR and confirmed that the plan is bad on any of these issues, on these grounds. Although it is certainly, as a three-judge bench, entitled to great weight. I think the tribunals and the Supreme Court have continued to uphold plans against such challenges, saying that the commercial wisdom of the Committee of Creditors is sacrosanct in this regard. Now,
Personal guarantee.
one more aspect of the challenge in SR was that I believe on behalf of the ex-promoters, an argument was made that personal guarantees cannot be kept alive where you have basically taken a huge haircut as financial creditors. But Justice Nariman dismissed that challenge as well on behalf of the ex-promoters and said that it can certainly continue. That is, the promoters and ex-promoters are not entitled to any protection in terms of their personal guarantees being released merely because under the plan, the financial creditors have decided to take a big haircut on the amounts owing to them as per the resolution plan offered as being offered merely because the resolution plan offered by the successful resolution applicant does not make allows for the continuation of the personal guarantees and for the banks and financial institutions to pursue these personal guarantors. Okay, all the questions on the pattern, etc., I'm not at liberty to provide. I've already clarified that. Now, I think at this stage, let me come to a couple of cases that I have not yet covered. One case, Common Cause versus Union of India. I think it is number 4. Please look up this judgment. It's 2008 5 SCC 511.
24.
I think it is question number 24 as correctly pointed out. This was basically, I think the petitioner filed a PIL where they sought various directions on how to prevent road accidents. These measures that they wanted included to set up proper procedures for licensing of vehicles, licensing and training of drivers, to prescribe appropriate procedures for suspension, cancellation of licenses in the event of default or involvement in accidents, to ensure provision of infrastructural requirements on roads, including sign signals, etc., etc., to minimize risk of accidents, to set up methodology for scientific analysis of accidents, to provide for education to all types of road users, to ensure immediate availability of ambulances, to set up road safety committees, and to enact a Road Traffic Safety Act. Now, basically, this PIL was dismissed by a bench of Justice Sema and Justice Karju, saying that the Motor Vehicles Act is an extremely comprehensive enactment on the subject. And if there are any lacunae or defects, it is for the legislature to correct it by a suitable amendment and not for the court to do so. And that these prayers amount to being legislative in nature, right? That is, the directions are legislative in nature. So, and then there is a strong indictment of PILs by Justice Karju, saying that they've become an uncontrollable Frankenstein and a nuisance, which is choking the dockets of superior courts, that judicial activism can be legitimate, for example, in case of Article 14 and 21 rights, but it would be illegitimate to declare a new principle of law that amounts to legislation, and that courts do not have the expertise to take such decisions. And because of separation of powers, the court can't really address these issues, and the court must not become a substitute for the legislature. However, Justice Sema has dissented with respect to certain observations after concurring with Justice Kaju on the main thrust of his judgment. He says that court should take a decision on PILs on a case-by-case basis, depending on the facts and circumstances. Then one more judgment which I'm covering. This is Municipal Corporation of Ujjain versus BVG India Limited. I think it is case number 45. So the Ujjain Municipal Corporation issued an invitation to tender for appointment of an agency to carry out door-to-door waste collection for a period of 10 years. They appointed a technical expert to scrutinize these technical and financial bids. The unsuccessful bidder challenged the award of the contract, which was allowed by the High Court, but the Supreme Court stayed the award by interim order and subsequently framed 3 issues. First issue was whether the High Court could question the judgment of the expert consultant on technical qualifications of the bidder when the consultant has taken into consideration various factors, including the basis of non-performance by the bidder. The second was whether a bidder who submits a bid expressly declaring that it is submitting the same independently and without any partners, consortium or joint venture, can rely upon the technical qualifications of a third party to satisfy the qualifications requirement. And the third issue is whether the High Court was justified in independently evaluating technical bids and financial bids of the parties as an appellate authority for coming to its conclusion. And here the court emphasizes yet again that where the High Court is not qualified to sit in judgment over an issue which is technical in nature, they should not interfere with the judgment of the expert consultant on technical qualifications of the bidder. And then they also held that to the extent that the bidder says he is independent, he can't rely on the qualifications of a third party or a proposed consortium member to qualify. And then the court states further in general terms, that unless the decision-making process, please remember that in general in administrative law, the court scrutinizes only the decision-making process and not the outcome or the merits of the decision in general. And here the court held that the decision-making process or the decision taken by the authority has to sort of be seriously malafide, arbitrary or perverse, or you must show that the authority intended to favor someone. Otherwise, the Constitutional Court will not interfere with the decision-making process or the decision, right? So this is the substance of this decision. Now, on SBP and Company versus Patel Engineering, you are aware that basically the Supreme Court reversed its earlier judgment of the Constitution Bench and held that the decision is basically quasi-judicial in nature. Sorry, it is not quasi. Oh, just 1 minute. Huh? is wrong, isn't it? It used to be administrative, then it was made quasi-judicial, isn't it? Huh? Unmuted. I'm unmuted. Just 1 second. Let me just clarify this. Yes, I'm sorry. My colleague was saying something which was not correct. SBP essentially reversed the decision of the Constitution bench. 7 judges reversed the decision of the Constitution bench. Justice Justice Thakkar, writing for the bench, held that the decision of the designate of the Chief Justice would be quasi-judicial and not administrative in character. Moreover, they barred the high courts from being entitled to go into the issue of the exercise of power by the Supreme Court under Section 11(6) in the case of international commercial arbitrations. And therefore, the High Court's decision is subject to challenge, but not the decision of the Supreme Court in an international commercial arbitration. Now, one more interesting aspect of the matter is that they confined the jurisdiction under Section 11 to whether or not there is an arbitration clause, largely, I believe, whether there is an arbitration clause between the parties, and all other issues were to be decided by the arbitrator. So, unless it is completely obvious that the arbitration clause does not apply, the court would not go into these issues. So it was, as correctly pointed out, it was a paradigm shift from Konkan Railways to SBP, saying that the decision was not administrative but would be quasi-judicial, right? So this is the sort of remit. Huh? Medical negligence, I thought I covered, no? Oh, sorry, there's one more judgment I'm to cover apparently, which is the medical negligence case in Balram Das. Balram Prasad versus Kunal Saha. I'm not sure. 3-0, I believe. So Balram Das is a medical negligence case where the issue was, one of the main issues was that while computing the compensation under the computing the compensation that was awarded by the Consumer Fora under the under the Consumer Protection Act in the context of medical negligence, the tribunal had come to a very low figure. The commission had come to a very low figure in the case of a brilliant young student who had a degree, I believe, from Columbia or some Ivy League college, the case says, in New York. And I know of only one Ivy League institution in New York City, that's Columbia, and if it's Cornell, then it's upstate. So she was from one of these institutions and had a brilliant career. Even as a graduate student, she was earning $30,000. And the tribunal computed the compensation based on that. So there were two issues. One is the commission had not gone into the issue of inflation, and the court cited various judgments for the proposition that you have to take inflation into account in these cases. It has been taken, you have to take inflation into account in these cases. And also, that you have to take into account the potential for future earnings and progress in the profession. So these aspects had to be taken into account, and the court therefore held that the commission was wrong in having limited the amount of compensation. So I think with this I'll close because we have already gone past 2 o'clock. And all the relevant cases have been discussed. So if it's okay, I've taken most of your questions during this and I have to go to a cremation. So I hope you won't mind if we close.
Sir.
Hello? No, I'm just ready. No, just hold. I hope it's okay. I'm closing it, huh?
Yes, sir.
Okay. All right.
Thank you, sir.
All the best to all of you, huh?